Please be seated. During this afternoon session, the trial chamber would like to declare to resume the initial hearing. And we already declared this morning, as the president of the trial chamber, I maintain my right to allocate tasks to our judges to handle some certain item of agenda. So I would like to now give the floor to Judge Cartwright, who will lead the discussion on the next agenda item.
Thank you, Mr. President.
Mr. President, Your Honours, I think perhaps it wasn't observed, but while the President was speaking, there was no translation.
Now, the trial chamber declares the continuity of our session, and as I already indicated this morning, on behalf of, as the president of the trial chamber, I reserved my right to allocate duties to our judges to handle some certain part of the item. So I would like to give the floor to Judge Sylvia Cartwright to lead the discussion on the next item of agenda concerning the issues relating to the witness list. So Judge Sylvia Cartwright, you have the floor now.
Thank you, Mr. President. As you have indicated, this section deals with issues relating to witness lists. The Chamber wishes to acknowledge receipt from the co-prosecutors, the defence and civil party groups 1, 2 and 3 of the lists of witnesses and experts they intend to have summoned at trial in accordance with Rule 80 of the rules, and additional materials as ordered by the Chamber on the 11th of December 2008. According to Rule 80, the civil parties and defence have 15 days from notification of the co-prosecutors list to file their own witness lists. The Khmer and English versions of the co-prosecutors witness list and additional materials was notified to the existing parties on the 5th of January 2009. The French version of that list was notified to the existing parties on the 14th of January 2009. All witness lists were filed within the prescribed deadlines. Parties having joined the proceedings after those dates have 15 days from notification of the co-prosecutors list to them to file their lists. Pursuant to Rule 80 bis of the rules, the Chamber will now consider these lists during this hearing. On the 5th of February, the Chamber issued a direction requesting additional information from the parties and the co-investigating judges. The Chamber has received the following information. On the 11th of February, the co-lawyer for Civil Party Group 2 filed a response with respect to witness number 8 of the witness list of that group, together with an article in English referring to that witness and describing her alleged detention at S21. On the 12th of February, the co-investigating judges indicated that they intend to interview a certain number of persons appearing in the witness lists filed by the parties. They further indicated that they will do everything possible to ensure that the scheduling of such interviews will not interfere with the trial chamber's scheduling directions. On the same date, the defence indicated that it did not contest the facts that proposed witnesses number 1 and number 2 of witness list of civil party group 3 intend to testify about. Witness lists received after the initial hearing will be considered upon receipt. The other parties will be given an opportunity to comment on these lists in writing. The parties will be informed of the Chamber's decision with respect to those lists by written decision. In the interests of good administration of justice, the Chamber wishes to know if, among the civil parties who are still entitled to exercise their right to file a witness list, any of them does not currently intend to file such a list, and if that is the case, if they expressly waive this right. The Chamber would greatly appreciate that information either this afternoon or later in writing. I turn now to the co-prosecutors' witness list. The co-prosecutors filed their proposed list on the 19th of December 2008 in Khmer and English. In addition, the co-prosecutors filed summaries of the facts to which each proposed witness and expert is expected to testify, and the list of new documents they intend to offer in the case. On the 24th of December 2008, the Chamber requested additional information with respect to the scope of the request for protective measures. On the same day, the co-prosecutors responded that their witness list could be notified to the parties and that they did not ask the Witness, Expert and Support Unit to conduct a risk assessment for witnesses Craig Etchison, David Chandler, Nayan Chanda, Nick Dunlop, and Françoise Sironi-Guibar. During the trial management meeting, the Chamber noted spelling discrepancies in the names of proposed witnesses KW03, KW11, KW12, KW14, KW19, KW22, KW28, and KW30, and asked the co-prosecutors to clarify this issue. The Chamber also asked the co-prosecutors to review personal information relating to proposed witnesses and experts Craig Etchison, David Chandler, KW25, Nayan Chanda, Nick Dunlop, KW34, and Françoise Sironi-Guibar. The Chamber acknowledges receipt from the prosecution of clarifications to their witness list filed on the 19th of January. The co-prosecutors indicated that those witnesses had already been heard during the investigative phase and provided the ERN numbers for documents relating to them. They also provided additional personal information on the above-mentioned witnesses where that was available. As noted during the trial management meeting, the list filed by the co-prosecutors contains 35 proposed witnesses and experts they wish to summon at trial. 2 of those witnesses, KW03 and KW04, are currently civil parties in the proceedings. According to the co-prosecutors, they were included in the list in case they decided to abandon their civil party status. Once the civil parties have made their decision concerning civil party status, early notification of any decision to renounce that status would be appreciated. The Chamber notes that any civil party whose testimony can be conducive to the ascertainment of the truth may nonetheless be summoned to appear in court. At the time they appear in court to testify, their status as a civil party will be taken into account. If they do not renounce their civil party status, the prohibition on taking the witness oath under Rule 23(6) will apply. All proposed witnesses are identified by their names as well as by pseudonyms. As indicated during the trial management meeting, the co-prosecutors estimate that a minimum of about 40 trial days will be needed for the testimony of the witnesses and experts on their list. The Chamber would now like to give the parties the opportunity to make observations on the co-prosecutors' witness list. The co-prosecutors will of course have an opportunity to reply after such observations have been made. Do civil party lawyers have any comments to make on the co-prosecutors' witness list? Mr. Khan?
Your Honour, no. I'm grateful.
Ms. Studzinski?
Yes, thank you, Your Honor. I would like to give our opinion on the civil parties KW04 and KW03 on the prosecutor's witness list, and we would like to inform the Chamber that these civil parties do not intend to withdraw their civil party status. And so far we have no other comment and do not object concerning the other witnesses and experts on the prosecutor's witness list. Thank you.
Thank you for that indication, Ms. Studzinski. Do any other civil party lawyers wish to make any observations? Thank you. Does the defence have any comments that it wishes to make regarding the co-prosecutor's witness list?
Thank you, Your Honour, says Mr. Roux. I have a few points regarding this list. We take note that, of the fact that in this list, the office of the co-prosecutors is, in fact, considering the testimony of 3 persons concerning the M13 detention facility. The defense would like to recall that M13 is not part of the facts falling under the jurisdiction of this chamber. And there is a very specific reason for this. M13 was no longer in existence by 1975, this latter date being the time for which this chamber has jurisdiction. This being said, the chamber will take note of the fact that these witnesses are called upon in relation to counts that obviously have nothing to do with M13, and for rather self-evident reasons. Since Duch is being prosecuted for crimes in S21, we, the defense team, do not understand why the office of the co-prosecutors insists on calling upon witnesses to talk about M13. This is what we find in the summaries of arguments, or the outlines of arguments. In particular, for KW32, it is stated that this person's testimony will be on the role of the accused in relation to M13, on the circumstances of the establishment of M13, and on the length of existence and the mode of functioning of M13. This is not part of our remit. It is totally outside the scope of what this chamber deals with. And it is more basically completely outside the ratione temporis jurisdiction of this chamber. Consequently, the defense would respectfully wish to request that these three witnesses be removed from the list as per their summaries. Furthermore, the defense would also like to state that it feels uncomfortable regarding summaries as they have been worded or submitted, rather generally speaking. Overall, I would tend to find all of this to be some copy and paste. It's copy and paste work rather than material that gives information concerning reasons for which such and such a witness would be summoned to appear. May I take just one example? But this kind of scenario appears for several witnesses. There is a kind of catchphrase here, which is the testimony of this person will be on the armed conflict, the role of the accused in relation to S21, the circumstances of the establishment of S21, and the length of existence and the mode of operation of S21. As you can see, M13 has here been replaced by S21. But this doesn't enlighten us any further as to the actual gist of the testimony. This overall phraseology is much too generic. And lastly, concerning the expert whose name you mentioned, Mrs. Sironi, the name is not confidential. I would like to recall that the two psychiatrist experts have on several occasions been in a position to examine our client at the detention center. The defense is, of course, in favor of both these experts appearing before this chamber. However, we would like to submit an oral request or an oral motion now. The defense requests that the chamber kindly ask these experts prior to appearing before the chamber to go and pay another visit during the time that will be required for such a visit to the accused in the detention center in order to update the earlier conclusions of their report, that report being now over 1 year old. Your Honor, these were our comments and our request. Thank you.
I have a few questions, please. I need to have complete clarity concerning the witnesses to which you are referring. Could you state the pseudonyms for the three witnesses that you referred to in relation to M13, please.
Oui, excuse.
My apologies, Your Honor. The pseudonyms are KW30, KW31, and KW32.
Now, in relation to the witnesses concerning whom you consider that inadequate summaries have been provided, can you give me those pseudonyms, please?
I'm referring to all the summaries, Your Honor. All the summaries seem to me not up to the standards of what had been agreed amongst us at earlier meetings.
May I infer that the second expert to whom you referred, along with Françoise Sironi-Guibar, is KW34?
C'est bien lui.
Yes, this is correct, Your Honor, this is correct.
Very much. Now, the co-prosecutors are invited to respond to those comments.
Thank you, Madam Judge. I will start by the end. I admittedly, and as everybody knows here, I'm not as familiar with civil law practices as is my learned friend and others here. I understand that he is making a request to the trial chamber that one of our witnesses be ordered or requested to do a certain act. Be that as it may, acceptably or not, in this types of proceedings, I have no objection to this process. I think it might be interesting to have indeed an update and would enlighten the trial chamber. As to the somewhat cursory criticism of our summaries of witnesses, these summaries were made specifically short because of the request by the trial chamber to have only 1 or 2 lines per witnesses indicating the relevance of their testimony. I find it odd that the defense would then hold our compliance with the trial chamber's request against us. To describe sometimes pages and hours of procès-verbal interviews in 1 or 2 lines and the relevance of that testimony to some of the most complex criminal infractions and complex factual situations, to do so in a few lines requires indeed to exercise a very summary description. And because all the elements of the crimes are the same, of course it bears that there would be repetition as to the relevance of these testimonies. I submit, therefore, that those summaries were in compliance to the best of our abilities to indicate to the trial chamber and to the parties how each of these witnesses would be relevant. We have tried, for example, when guards were involved, to specify what part of their duties, let's say, or experience as guard was different from the others. As the trial chamber may recall, we had summaries that were prepared of 1 or 2 or 3 pages for each of these witnesses that went into great extent about what we thought were the relevancy of each of these witnesses. Following the trial chamber's instructions, we reduced these pages of summary to 1 or 2 lines. I would offer right now to the trial chamber and to any parties to forward these extensive summaries of each of these witnesses so that the parties can be perhaps better informed and the trial chamber make a more informed decision. However, again, as I said, we complied to the best of our abilities with the trial chamber's instructions in this, and I submit that that criticism does not have a valid foundation. As to the witnesses that refer to M13, can I first note that one of those witnesses I apologize to take the court's time in trying to find the proper pseudonym. KW08 is admittedly an old-time colleague and co-perpetrator of the accused who did initiate his career at M13 and then follow it onwards to S21. And provides indeed, obviously potentially tainted, but very compelling evidence that it would be relevant to the proceedings. I think that witness's usefulness to the trial chamber should be obvious. As to the other 2 witnesses who are indeed called or would be called by the co-prosecution to address the events of M13, let's be clear. Everybody knows what our jurisdiction is legally, personally, and temporarily. Everybody knows as well, especially those involved in international criminal trials beforehand, that these trials do not operate, nor do they tell the story in a vacuum. Crimes are committed within a country. Are we going to tell us that we cannot talk about Cambodia because it's irrelevant to the jurisdiction, because it existed prior to 1975? No. I note, interestingly, that the defense wishes to call several of the accused old friends and neighbors, I believe, to establish certain facts. Is this irrelevant? Is this not helpful? We do not intend to contest the defense request to call these witnesses that will testify to events quite extemporaneously. They are useful to the proceedings. The witnesses who worked for the accused at M13, and at least for one of whom eventually became a detainee at M13, will testify to relevant facts for this court. Part, if not the major part of the defense, rests on the character of the accused, or at least so do the witnesses will testify to. Furthermore, during the course of the investigation, the accused has made several assertions concerning his commitment, his actions at S21, his state of mind while committing the crimes. You will have to weigh that state of mind to properly assess the criminal conduct of the accused. That state of mind, however, did not in and of itself spontaneously generate in March 1977 when the accused took over S21. It dates back to his long-term commitment to the aims of the Communist Party of Kampuchea in its persecution of perceived enemies. His support for those policies is indeed his lifetime dedication up to 1979, and actually even later than, up to the 90s. My learned friend knows full well that witnesses who testify to the state of mind of an accused during the commission of the crimes need not have their knowledge based only within the jurisdiction, the time jurisdiction of the court. The court needs all the facts to assess properly not only the commission of the crime, but the intent behind the commissions of those crimes, and intent is understood best when the whole picture of the criminal conduct and that of the accused is put before the judges of facts. That is why we submit that those two witnesses, those who will testify or would testify should they be heard, and whose testimony we requested to the trial during the investigation, those testimony will be relevant for what is now the case before you. And if it please the court, my colleague would like to address the court.
Ms. Chey Liang.
Thank you, Your Honor. As my colleague already indicated in the special case, and that the co-prosecutors would like to call KW 30, 31, and 32 witness, and we know that these three witnesses have been summoned because there has been a related jurisdiction to the M13, but these M13.
But before it started at S21, the victims were gathered together at an office called PJ near the Platmai market. So the temporal jurisdiction continued from M13 to S21. And the prosecution thinks the temporal jurisdiction continued. And those witnesses know about the facts related to S21. For example, the power, the infrastructure and the organizational structure of the S21, the detention and the torture or the killing at M13. So those witnesses think there's a link between the situation at M13 to S21. That's why the prosecution intends to suggest and propose the judges to consider these issues and to hear the testimony of these witnesses during the substantive hearing. Thank you.
Yes, thank you very much.
Madam.
You wish to respond? Very well, Mr. Wu.
Mr. Hu, thank you, Your Honor. Perhaps first, to dispel any misapprehension on the part of my learned colleagues, my learned colleague, Mr. Petit, referred to KW08. He is not one of the three people that we asked to be struck off the list. I did not refer to KW08. Furthermore, in the summary of the co-prosecutors of the testimony of KW08, reference is made solely to the events at S21. So I said nothing about KW08. I only refer to KW30, KW31, and KW32. Obviously, with regard to this issue of M13, we consider this to be an important point. The Chamber will not be unaware that if the Office of the Co-Prosecutors heard about M13, it may have mistakenly, of course, omitted to call one of the major witnesses of M13, whom we all know. But that must be an oversight on their part. So you cannot have a trial at double speed or at different speeds. The defense has said previously that it did not intend to answer questions to be put by the co-prosecutors pertaining to events at M13. And if the rule of law needs to be recalled here, on no account can the accused be charged before this court for events that occurred in M13. But I hear my learned friends on the other side saying that they do wish to go back to these events. It is not possible from a legal standpoint. And I repeat, it would not be fair. Thank you.
Yes, thank you, Monsieur Roux. I will now turn to the witness lists filed by the civil parties. As indicated during the trial management meeting and referred to today, there are 4 such groups. Civil Party 1 is represented by T. Srinner, Karim Khan, Ellen Werner and Brianne McGonigal. The Chamber received the witness list from this group yesterday, the 16th of February, and has not had time yet to review it. It contains 5 proposed witnesses. The deadline for the filing of witness lists for this group expires on the 4th of March 2009. I would like to inquire of counsel for Group 1 of the civil parties if they intend to waive their right to present any further witnesses, a list of any further witnesses.
Your Honour, I can say yes with one caveat. It will be the intention to seek to call Norg Chanpal should our earlier application be granted. With that caveat, there would be no additional request to supplement the proposed witness list.
Thank you for that indication. The witness list for Civil Party Group 2, which is represented by Hong Kim Swan, Jung Panet, Kong Pisi and Silke Sturczynski, their list was filed on the 19th of January 2009 in Khmer and English. In addition, this group filed summaries of the facts to which each proposed witness and expert is expected to testify, and the list of new documents they intend to offer in the case. The list filed by this group of civil parties contains 10 proposed witnesses and experts they wish the Chamber to summon at trial. All the witnesses are identified by their name and a number. 7 of these have been assigned a pseudonym. The Chamber, for the purposes of this hearing, will use the pseudonym Witness CP2 with an assigned witness number for all witnesses on this list, until the risk assessment of these proposed witnesses has been completed. Where pseudonyms have been assigned by the party, the Chamber will, for clarification, add this pseudonym between brackets. One of the proposed witnesses in this list is an alternative witness in case witness CP28 or A07 cannot be located. The lawyers for Group 2 estimate that a minimum of approximately 8.5 or 6.75 trial days will be required for the testimony of the witnesses and experts on their list, depending on whether witness A07 can be located or not. In its direction requesting additional information in preparation for the initial hearing, dated the 5th of February, the Chamber asked the civil party lawyers to provide additional information concerning witness CP2, 8 or A07 on their list. In particular, to provide any evidence that she was detained at S21. On the 11th of February, the civil party lawyers filed an article written by witness CP2 9 in 1991 mentioning this witness CP2 8 or A07 and describing her detention at S21 as well as the torture she was subjected to. No additional information was received. The Chamber would now like to give the parties an opportunity to comment on the witness list of Civil Party Group 2. Civil Party Group 2 will have the opportunity to reply after all observations have been made. First, the co-prosecutors. Do you have any comments?
Thank you. We would have comments to make on, and if I understood your directive, witnesses A03, A02, and A01 of the civil parties list. These comments have, well, I would request guidance from this trial chamber. The comments that I have regarding particularly A01 and A02 might force the debate or to go either in camera hearing or might indeed refrain or prevent me from making the most useful argument before this trial chamber. With your permission, if that is agreeable, I would like to reserve our right to file in writing our consideration regarding these three witnesses by forthwith, if not tomorrow, certainly by the day after tomorrow, and giving therefore the parties an opportunity to answer, and then the trial chamber to properly assess our misgivings, which are, I submit, serious and well-founded about, again, A01, A02, and A03. As to the rest of the witnesses, we do not have any comments.
Yes, thank you, Mr. Petit. We will be going into private session later to consider some aspects of witness lists, and that may be an opportunity then, or alternatively, we can indicate that you can file those comments in writing. However, I was focusing primarily on the CP28 or A07 and CP29, who is the witness being called to be called in substitution. You have no comments relating to them?
Thank you. No, we do not certainly have any objection, that is.
Yes, thank you. Do any of the other civil parties have any comments to make? Mr. Khan?
Your Honour, I am most grateful. Perhaps, with your indulgence, I would ask to go back for a moment to the motion that we filed yesterday. We dealt with the list filed rather quickly. I do make for the record an application to vary this motion to the extent that it should be considered not only under Rule 80 bis, but also simultaneously under Rule 31 of the internal rules. Your Honours, the reason I say that is that it is very clear from Rule 31 that any party may invite Your Honours to call any expert that may assist you to properly and fairly determine this matter. And that application, of course, is open to the defence, to the civil parties, and the prosecutor. Some consequences could flow from whether the application is granted under Rule 80 bis or Rule 31. This is because, Your Honours, from the plain reading of Rule 31, it is clearly mandated at paragraph 11 that should Your Honours accept a proposal to call an expert, the court will foot the bill. The court will pay for the expert to attend. The difficulty in all candour that we face and we present to Your Honours is, whilst my legal team is acting completely pro bono, with the caveat of one member that is assisted by the British Embassy, the experts we've contacted will not be able to work pro bono. Some are internationals. Your Honour, so I would ask that an oral application be entertained when you're considering this motion, and it is considered both under Rule 80 bis and Rule 31. Your Honour, in addition to that, it is my submission that if you are minded to only consider the application under Rule 80 bis, I would invite Your Honours to give clarity to the ambiguity in the rules and give guidance to the parties as to whether or not, in Your Honour's view, given that these are witnesses that the court will consider are relevant and pertinent to the determination of matters and to the fairness of these proceedings, whether or not a declaration should be made to assist all parties in this courtroom that the court will in fact fund and pay for the witnesses to come to this court and either to give viva voce evidence or alternatively to prepare expert reports that can be filed in the usual manner. Turning now to the issue of the witness list of civil party group number 2, and whilst I do fully accept that Your Honour's concern was in relation to some other witnesses, it would be remiss of me, in my respectful submission, if I did not point out, on behalf of the civil party I represent, that we have the very gravest of misgivings regarding the first 3 witnesses on the witness list put forward, namely A01, A02 and A03. Your Honours, there is no indication from the face of the witness list submitted by civil party group number 2 that any contact has been made with these putative witnesses. That is my first point. The second point is that it is very clear from the face of the application and the witness list that summonses are being requested. Your Honour, it is a clear principle of law in my submission, both in the domestic context of Cambodia, also as a matter of international law, as evidenced from the practice of the Yugoslav tribunals and the Rwanda tribunals, that before a subpoena, a summons under Rule 41 of this court, a subpoena ad testificandum, whatever one wishes to call it, is sought, a party must persuade the trial chamber that that witness is not otherwise willing to attend. No such threshold argument has been made out by the civil party group number 2 in this case. That is my second ground for objection. Your Honour, the third is in support of the prosecution's opposition at this stage, and of course our obligations under Rule 23 to support the prosecution, is that it would be perilous in the extreme for any party to call a witness when they do not have in good faith knowledge of what the witness is going to say. We have spoken in relation to our own witness list to the 5 experts that are before Your Honour. We have with reasonable certainty been able to detail the parameters of their proposed testimony. There is no indication from the motion put forward or the filing put forward by civil party number 2 that similar diligence has been displayed. It is pertinent in this regard, in my respectful submission, and bearing in mind the obligation to support the prosecution and not torpedo it by unexpected and unknown witnesses whose focus of testimony is a matter of speculation at best, to bear in mind the wise words, in my respectful submission, of the appeals chamber of the Yugoslav tribunal in the Krstić case. Your Honours, for the record, I will cite that decision. It is the decision on an application for subpoena dated the 1st of July 2003. Your Honours, I will invite you in due course to look at paragraph 8 of that decision of the appeals chamber of the Yugoslav tribunal. If I may quote, the appeals chamber accepted, and I am quoting directly from the decision, in a situation where the defence is unaware of the precise nature of the evidence which a prospective witness can give, and where the defence has been unable to obtain his voluntary cooperation, it will not be reasonable to require the defence to use, quote, all mechanisms of protection and compulsion available, end quote. The appeals court chamber of the Yugoslav tribunal continued, in order to force the witness to give evidence cold, in court, without first knowing what he will say. Your Honours, this is the important bit. That would be contrary to the duty owed by counsel to their client to act skillfully and with loyalty. Your Honour, this is not rocket science. This is not something that is a matter of sophistication. But in order to properly call a witness, even a witness that one can establish to the required standard has said that they are unwilling to come, one must be able to, with some degree of precision, tell a court what one believes the witness will say and give a basis for it. Your Honour, what I would propose, with the greatest of respect, is there is a clear power under the rules of this court, Rule 41, for summonses to be issued. The proper course of conduct, in my respectful submission, is not to go blindly forward into uncharted territories, but for a moving party to seek a summons in order to compel the attendance of an individual to attend an interview, not to come to court, but to attend an interview. That this is a possibility is supported by the clear jurisprudence of the ad hoc tribunals, and I quote again the Krstić decision of the 1st of July 2003, this time at paragraph 10, where the appeals chamber, referring to Rule 54 and powers of subpoena, which in material respects, in my submission, is very similar to your Rule 41 here, said, and I quote, "Such a power clearly includes the possibility of a subpoena being issued requiring a prospective witness to attend at a nominated place and time in order to be interviewed by the defence where the attendance is necessary for the preparation or conduct of trial." So, Your Honours, this general principle is open, in my respectful submission, not just to the defence or to the prosecution, but also to civil parties. But a number of hurdles have to be overcome first by a party, particularly where the prosecution have intimated that calling such witnesses is unhelpful. Your Honours, in considering the scope or the merits of the submissions I have just sought to adumbrate, it is also it may also be useful to bear in mind that Rule 23, in my respectful submission, operates not only as a rule of thumb which should guide the civil parties, but as a limiting factor as to the scope of operation which is open to civil parties in the pursuit of representing their clients. It cannot be, to put a completely different case to Your Honours, it cannot be to contradict the prosecution in a manner that causes confusion. The whole purpose of civil party intervention, in my respectful submission, is to support the prosecution, not to follow them slavishly, but to assist the prosecution so that your honours can get to the truth. But your honours, in relation to the merits of this particular matter, there's been no indication that the witnesses have been spoken to. There's been no indication that the witnesses are unwilling to attend and therefore justify a subpoena. And in any event, the third point is, if a subpoena is necessary at all, or a summons under Rule 41, on the facts of this case, it should be granted to compel their attendance to meet with the civil party concerned for an interview, and only after that stage will the civil party, in my respectful submission, be more properly able to appraise your honours as to the merit and necessity of calling the requested witnesses for trial. Your honours, those are my submissions in relation to the filing by civil party number 2, unless I can assist further.
Thank you, Mr. Khan. Does any other civil party wish to make any observation? No? The defence, does it have any comments it wishes to make?
Merci, Madame.
The defense. Thank you, Your Honor. The defense wishes to take the floor, but not on the Group 2 list. We shall leave that discussion to those people who have just had it. We have nothing to say about that. We watch with keen interest, or we await with keen interest what will be said on the other side. However, the defense wishes to inform the chamber or share with the chamber the questions it is asking itself with regard to witnesses that are yet to be named under list number 1. This is for the civil parties who have secured interim recognition and who still have a time limit to comply with. The defense would like, once these witnesses are known, to be able to make observations and, if applicable, to call counter witnesses if this is necessary. We understand that further time was granted to some civil parties. It is, in all fairness, in our view. But then, the defense, if it became necessary, should be afforded an opportunity to call witnesses in rebuttal.
Your Honour, if it assists, may I just say...
Well, I'll just respond briefly to that first, Mr. Khan. Monsieur Roux, you will be given the opportunity to respond to the witness lists yet to be filed, and the trial chamber will consider your other concern. Mr. Khan?
Your Honour, I'm grateful. I just wanted to go on record as saying that I would fully support the position put forward by my learned friend for the defence, that should additional witness lists be filed by any party, it's only right and proper that an accused should be able to review their witness list and decide if other evidence is necessary in order to rebut or contradict or clarify the evidence that they've just received. So, Your Honours, I would support my learned friend's proposition.
Thank you, Mr. Khan. Now, do Council for Civil Party Group 2 wish to reply to the observations that have been made? Ms. Studinsky.
Yes. Thank you, Your Honours. First, I would like to ask the chamber if it is first possible, but also if the chamber has already tried to locate witness 8 or CP 28 And if the chamber, if it has not been done yet, intends to invest and to find out with the information that I have provided the chamber with, to find out an address of this witness. Yeah.
I'll just briefly ask the President to deliberate on this matter, the student.
Okay.
Yes, Ms. Studinsky, this is a matter that has concerned the trial chamber, and it will be deliberating on this very point and indicating a decision, hopefully, during the course of the initial hearing. Just as one extra point, do you have any further information concerning the whereabouts?
No, unfortunately not, except this document that I have, or we have submitted already. And
do you refer to the interview?
Yeah, exactly. And but I think maybe there are still information that I have given that allow the chamber to proceed and to conduct own investigation on this, or maybe, for example, I indicated the working place, the former working place of this witness or the translator during the interview, and so on, and even also the address of the journalist. And but so far, I have no other information who can assist the chamber.
Can I inquire if you have made any efforts to locate the proposed witness CP29, the one who did the interview?
Yes, I had contact with this witness, CP29, and he agrees to provide as testimony here. And so I received also, as I've indicated, his address where he can be summoned. And but I have no further information received about details, maybe about the interview or something like this. Maybe the chamber could request again the journalist.
Do you wish to respond to any of the other matters raised by the other parties?
Yes, I would prefer to follow the suggestion by the co-prosecutor and to deal with this whole issue of witnesses CP21, 2, and 3 in closed session, and I only want to respond now so far and add that we are here before the ECCC, where Cambodian law is applicable, and I find no indication until now that the raised questions by the group number 1 are not covered in the CPC or in the internal rules, so that guidance in international procedures, and so he referred to the ICTY. This guidance is not necessary to assess if these witnesses should be heard or not. All further comments, I would like to reserve my right to comment this, but I would request the chamber to do this in closed session. Thank you.
Yes, thank you. I'll now... Sorry? You?
Yes. Je souhaiterais avoir...
I would like to seek a clarification from Mrs. Studzinski on CP28, witness CP28. It appears to me that the lawyers of Group 2 were asked to clarify whether this witness had any kind of evidence to support the fact that this person had been detained at S21. At this particular stage, do you indeed have any information, supplementary information that you might provide to the court?
Concerning the link between this witness, CP28, and her imprisonment in S21, I have the interview that is mentioned in a press release from 1991, and quotes this witness as a prisoner in S21 who was submitted torture, and in particular sexual torture in S21, and which these evidence and testimony that she gave to the named witness CP29. And Your Honor, I think this should be for the moment enough to show this link between this witness and her imprisonment in S21 and the further story about the sexual violence and the mutilation. Thank you.
Avez-vous
Judge Lavergne, have you done any verifications as to the lists of detainees in the file?
So far she is as under this name not mentioned as a detainee, but she is mentioned in a book which is a collection of documents related to the trial from 1979, and appears there as a witness, but at this time not being asked or without any relation to the details about the sexual violence in slang, but more general statement. Thank you.
Judge Lavergne, in this latest document that you're referring to, the witness, did the witness mention that she was incarcerated in S21 and that she was subjected to sexual violence there? Is there any mention of this in the last document that you have just referred to?
Sexual violence, as I said, is not mentioned in this book, but her imprisonment.
Yes, well, thank you. I would like now to note that the deadline for Civil Party Group 2 for the provision of witness lists expires on the 4th of March next. I'd like to inquire if this group intends at this stage providing any further additional witnesses.
Your Honours, we will indicate as soon as possible, and I think really in the next day and before 4th of March, if we want to submit an additional witness or document list. There is only one witness still pending, and I cannot today, I'm not yet able to clarify or to tell the chamber if we will call this witness, and so we can only tell you that we will indicate it as soon as possible, and in the case that maybe also withdraw the right to submit an additional witness list if we have the information before the 4th of March. Thank you.
Yes, thank you. Well, the Chamber notes that you have indicated that you will not be waiving your right, and of course you have until the 4th of March to file any further list of witnesses.
The President. Now the proceedings of the session is according to the agenda. However, according to our schedule, we will have a break in each morning and afternoon session. Now it's a break time. We will have a 20 minutes break, and we will return and resume at 3 p.m. Please return to your seats before 3 p.m. Thank you. Please all rise.